Hello, and welcome back to Coin Lady channel. However, I must give credit to the XRP community Mac Attack XRP for publishing this. It made me laugh, that's for sure. Is there any chance that this could actually happen? I can't say. The two of you informed me. But while we wait for the SEC versus Ripple case to be resolved, or at least for Judge Torres' decision because, let's be honest, this thing could go to jury trial, I wanted to share some thoughts with you in this video. While we wait, however, attorney John Deaton has provided some fascinating details. He then listed the top 5 possible resolutions to the SEC versus Ripple case. And it was interesting to state, and I'll even tell you here at the outset of the video, this one of the things that I thought was the most positive. Even if the SEC wins, attorney Deaton thinks it's very likely that Judge Torres is going to write up an opinion regarding secondary sales of XRP. I'm sorry if I'm beating a dead horse by saying this again, but you get the gist of my joke. Keep hammering away at this theme, this concept that I've mentioned numerous times in recent times. What matters most to us here in the US as XRP holders is that there is a path forward for XRP in the US, but global markets are going to react regardless of the outcome of the Ripple case. Still, it will frighten the market participants who are waiting outside. If there is bad news on this front, it could have repercussions for other alternative cryptocurrencies. However, before we go any further, I do want to clarify something. I come from no financial or legal background. Nothing I say or write should be taken as recommendations to buy or sell any particular security. Just a hobbyist here who occasionally posts videos to YouTube on various crypto-related topics. Okay, then. The Wolf of Wall Streets is a well-known figure in the crypto community. Scott Melker, with 888,000 of his devoted fans. Recently, he wrote on Twitter, "This is the 29th of March. Imagine," he said, "if the SEC were to lose a court case against Ripple. Imagine that." The lawyer John Deaton did that today. About 5 hours ago, lawyer John Deaton tweeted out this thread in which he discusses various outcomes and offers his 5 favorites. Here is what he came up with. Imagined XRP outcomes best case scenario, Ripple wins outright and the SEC is smacked for its outrageous behavior and overreach. In parentheses, he adds that Judge Netburn has remarked that SEC attorneys are hypocrites who don't have an unwavering commitment to upholding the law and who are instead more concerned with achieving a favorable outcome in their current case. And so, that's all I can think of right now. Judge Netburn's utter contempt for the SEC in this case is probably my favorite thing I've seen from either Judge Netburn or Judge Torres so far. And obviously, Judge Netburn and Judge Torres were chatting it up. The presence of at least one lawyer in the XRP community was readily apparent to me. Maybe it was Attorney Hogan, maybe it wasn't. Well, yeah, they'd probably be to whatever degree, having communication, whether it's sitting down at lunch and talking about this stuff or whatever it is, I can't recall off the top of my head, but I remember one of the prominent attorneys in our community was noting. Since Judge Netburn was openly and justifiably dismissive of them, I can't help but speculate about what Judge Torres might be thinking as he makes the final decision and decides whether or not to bring this to trial, which is, of course, always a possibility. But in contrast, Judge Nepper and she's just a magistrate judge or, as I call it, a helper judge, because there's so much work for her to do. The assistant judge, Judge Netburn, was working through all the discovery issues. It's fascinating, though, that you were able to arrive at such conclusions. Then there was a close second. Judge rules Ripple offered XRP as an investment contract, also known as security, early in the XRP ecosystem on a few specific instances, such as the brochure sent to 100 potential investors in 2014. This was the second best outcome written by John Deaton. However, the sale of XRP in and of itself, or in secondary markets, does not constitute the sale of a security. And I was just talking about that the other day, maybe a day or two ago. It's a pretty niche topic. I don't know how well known the brochure's case is, but back in 2014, Ripple was distributing them. They weren't trying to sell XRP to retail investors or anything like that, but a judge can draw whatever conclusion she likes. In that case, could she possibly rule that it's illegal? It was her option. How likely that is, I can't say. I can't say for sure, but it's possible. But even if Ripple were to lose this particular case, there is still a real and potentially lucrative future for XRP. And now for John Deaton's third best result. He claims that the judge has ruled that a jury must decide the disputed facts and has denied summary judgment requests from both the SEC and Ripple. So, things will continue as they have been for the past year. However, the judge emphasizes that XRP is just code and that secondary transactions do not constitute the sale of a security. Yes, now that I'm an XRP holder, I would still be equally or nearly equally thrilled for any of those three. I'd be reasonably content as long as there's a way to move forward. In general, I favor the most straightforward explanation. The question remains, though, of whether or not that is sufficient to get XRP relisted on cryptocurrency exchanges. At this time, I believe the correct response is yes. I can confidently argue that the answer is yes. Is that what you think is most likely? Hell yes, I pray so. Even if that were the case, I still doubt that Coinbase would be the first exchange to release cryptocurrencies based solely on their track record of supporting new technologies. And while it's possible that other exchanges will follow Coinbase's lead, it's important to remember that XRP spiked to nearly $4 at the start of 2018 before it was even listed on the exchange. Coinbase isn't required for XRP to have that kind of a run. The fourth optimal result is as follows. John Deaton writes that a judge has ruled in favor of the SEC in a case involving the sale of XRP as an investment contract in the past and the present. However, the judge emphasizes that the secondary market for XRP has no bearing on her decision. And a law of ripples. The situation has remained unchanged for years. Once more, it's natural to have questions in such a predicament, and you probably will continue to do so even if the judge provides some clarity, as I very much hope he or she does. Would that be sufficient for trades to the point where we'd still be stuck? The fifth scenario he presents is the most dire of the five he describes. Like the judge in the library case, Attorney Deaton claims the judge grants summary judgment in favor of the SEC and makes no comments about the token or secondary markets. Later, at a hearing on damages related to secondary sales, I would try to replicate my actions in the library. Yeah, so I'm sure you'll remember that the ruling in the library case came down, I believe, at the beginning of November. The library had failed. That doesn't even remotely resemble the Ripple case, and the arguments presented there are entirely different. Therefore, in my opinion, the outcome of that case does not portend a string of terrible decisions from Judge Torres. In a similar vein, for Ripple or XRP in particular. However, John Deaton, an attorney, has stated that he will repeat his actions from the library case if this occurs. So, he did end up, being in court for the remedies portion, and he did end up filing an amicus brief. That would put it around the last of the month of January this year. And it was significant, very positive, because the judge has stated in court that when he writes up his ruling, which is not public at this time, it is on record, including the remedies portion, which was the focus of the hearing. The transcript will state explicitly that secondary markets are excluded from this. A huge victory, indeed. I'm sorry for Library and Jeremy Kaufman, but that's great news for everyone who cares about the future of the credit token. So, you could see something like that here, even if it's something I hope we don't have to go through, because then it's probably months before you get to the remedies portion, and then it's a question mark. So, what does Judge Torres say in that case? But even if that did occur, it might still be a huge victory. Even now, it is possible. Even the worst-case scenario out of these 5 possibilities has the potential to be beneficial in the long run, though it might cause global market chaos for a few months in the short term. I believe Judge Torres is aware that her ruling will have far-reaching consequences for the entire world, with the possible exception of North Korea. Yeah. Additionally, Attorney Deaton added, I've already gone on record to say a few things. The SEC's motion for summary judgment in its case against Brad Garlinghouse and Chris Larsen will be denied by Judge Torres. The best-case scenario for the SEC is that the judge will let the jury decide whether or not the 2 executives acted recklessly. The judge will probably rule in favor of the 2 parties. Management personnel, because no fair jury could find them reckless. Within parentheses, he adds, USA now calls XRP virtual currency in 2014, FinCEN 2015, FSOC 2019. According to Hinman's presentation, MoneyGram SEC employees may hold XRP until 2019. And so forth. I think Judge Torres will have something to say about secondary markets and the token itself, he continued in his letter. Important, 3,500 affidavits and an amicus brief from XRP holders. It's important to drop the coin, turn on the jets, and file those amicus briefs. The judge is aware of the gravity of the situation. And that's why I've said that everyone who has responded in any way is a vital cog in this wheel. When you're just one person, it's easy to wonder if your existence even matters. No, it's all relevant. Everything adds up. The whole thing adds up. We're talking about 3,500 sworn affidavits and the roughly 76,000 XRP holders that Attorney Deaton represents. What a huge step forward. Simply put, this is something of which I am unaware. Some businesses have even threatened to spin the bits or tap the jets in the event of a negative ruling regarding XRP in this jurisdiction. This is completely unreasonable and unfair, as it would have devastating consequences for us. The judge is aware of this, but she is still approaching the case objectively. How could she not do the right thing if she discovers Ripple did something wrong, which is a big if? Finally, Attorney Deaton concludes by arguing that you must side with Ripple if you want an absolute victory with no room for compromise. The SEC's legal theory in this case is far too broad and ambitious to be successful on its own. The question is how far Judge Torres will go. Visit in search of targeted deals and price reductions. Well, that's an excellent question because the SEC didn't reference any particular deals. They took a completely unreasonable approach and attacked everything in sight. This is something completely new to me. And sure, I don't have a background in law, so why should he? But what I mean is that in the 2 years and counting that I've been writing about this, nobody has ever brought up anything remotely resembling a precedent for this. The situation is unprecedented. In a word, it's crazy. So, once again, I'm very hopeful, albeit somewhat wary. When compared to the library case, I have a lot more hope for this one. So, it looks like we'll have to hold tight for a while longer. But now we're so close to the end. And listen to what Attorney Deaton has to say. He's a lawyer, so that's cool. He, not I, is the legal expert. In general, all of these are positive outcomes, some more so than others, and even the least optimistic sounding of the bunch, the last one, is not necessarily doomed to failure. If Attorney Deaton is allowed to intervene during the remedies phase, he or she may attempt to obtain clarification regarding secondary market sales. So, tell me what you think, okay? I'll stop rambling on now, but I really am happy about this. Please share your thoughts in the space provided below. Let's continue talking about this. Please don't think of me as a financial advisor. Nothing I say or write should be used as a basis for making financial decisions. In the end, please like and subscribe my channel. See you later, bye.